channel. I am still discussing disability advocacy. And today I want to talk about guardianship. Not in the normal sense that you would think of guardianship. A lot of people think guardianship is only needed when they have an elderly family member who can't take care of themselves. I'm talking about guardianship that is necessary when you have an adult child with a disability who can't sign documents, enter into contracts, or make decisions for themselves, who can't care for themselves. Okay, now some of the adult children can be their own guardian. It's just going to depend on their level of disability. Okay, so there are two ways to gain guardianship. You can go through the Health and Human Services Commission. So in Texas, the Health and Human Services Commission does have a guardianship program. But before filing an application for guardianship, the HHSC, they must obtain a CME, or a document establishing intellectual disability. They must ensure that the proposed guardian has a source to pay for their care, and they must determine if guardianship is the right course of action. Because sometimes there's other things that can be worked out. Or you can go the independent route and get your own attorney to file for guardianship of your special needs adult child. This is expensive. This is time consuming. You can also contact your local university. The law department, the legal department, has internships that will do this gratis. So that is actually probably the best way to go, because it helps both. It helps the students, and you don't pay a fee. However, you're at the mercy of the professor who is overseeing the project. You're at the mercy of their schedule. So, if you think you need to get guardianship, you need to do that immediately after the adult child turns 18. It can't be done before then. It has to be done right after they turn 18. Okay. Let me give you a scenario. Let me tell you why this is so important. Okay? Let's just take this scenario. The child is under 18. The child turns 18. You've been caring for the child because you're the caregiver, or you're the mom, or you're the dad. Okay, boom. Child support has stopped. The child is 18. The child has a lifelong disability that prevents him from ever obtaining gainful employment or living independently. He receives $708 a month in SSI. He requires a team of 22 caregivers, teachers, paraprofessionals, and professionals, some 24/7, to care for him, including you. As his lifelong caretaker, you have given up certain career paths and sacrificed decades of employment, advancement, and opportunities, thus putting you in an equitable position economically to supplement the void of any possible child support. Okay? So this child has an ARD approaching. That is annual review determination. An ARD from school. Okay, they can also age out in school. They can stay up until they're age 21. But let's just say that this child is turning 18. This child has turned 18. And this is before school is out, and they have an award coming up. What are you going to do? You can't sign on his behalf because the law says he's an adult. The school understands, but they have rules and laws they must abide by. Well, too bad. You just have to sit and listen. You can't participate. You can perhaps advise, but you can't sign because they are an adult in the eyes of the law. You can no longer access his bank account to pay his bills because he is no longer a minor. He is an adult. His father refuses to pay child support or even concede that he has a disability all of a sudden. And you have missed opportunities to apply for certain state-funded programs that ended at age 18 because you thought that his father would continue to provide the meager support. You are now faced with a complex problem that even the Attorney General cannot fix. First, you must gain guardianship of your special needs child. This is a complex, emotionally and financially painful endeavor that must begin after the child turns 18, not before. And as I just mentioned, there are a couple of other methods, by going to the local university and seeking out their legal department. And that way you are not charged a fee, but you are at their mercy. It can take months, maybe even a year, which is not good. Okay, so it has to be done after the child turns 18, not before. So you must sue your child. You literally must sue your child. You must have him served. You must go before a probate judge and face interrogation by your child's ad litem attorney. That is his court-appointed attorney who will grill you. It can be embarrassing because, my gosh, you're the child's parent. You know the child. You know what's best for the child. And who is this guy asking you questions in court? Well, you have to go through it. Once a judge grants you as guardian, you must make annual reports, document visits, and report to the state guardianship case manager. You must request and pay for new papers every year, and then distribute to each of your child's case managers. Your child will no longer have voting privileges. Excuse me. But you are now your child's voice, and you must speak. So if this particular scenario resonates with you, you know what must be done. You're going to have to do it. There's just no way around it. You're going to have to do it. I can follow up on this later in another video and get more in detail about this, but there are 4 different types of guardianship in Texas. This is important. There's the guardian of the person, full or limited, guardianship of the estate, full or limited, guardianship of the person and the estate, and that is what I highly recommend, or temporary guardianship. No. Okay, so if you do have a special needs person in your life, someone with a disability, an adult child with a disability, this is what I'm specifically referring to, I highly recommend guardianship of the person and the estate. I'm not an attorney. You should get one. But that is my recommendation, and that is the basic process, and that is the sad truth and the steps that you have to go through in order to gain guardianship. That is all.